This meeting is being recorded.
Thank you. Good afternoon, everyone. Welcome to our Enforcement Committee meeting. I'm calling the meeting to order. I have 11:59 a.m. And this meeting of the Board of Chiropractic Examiners Enforcement Committee is being held by teleconference pursuant to the statutory provisions of Government Code Section 11133. The date is Thursday, June 8th, 2023. The time is, 12 o'clock to be exact right now. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless in the discretion of the committee circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items, except to decide whether to place the matter on the agenda on a future meeting. Please be aware that this meeting is being recorded. Please turn off or silence all cell phones. And we will now take the roll. Dr. Paris, will you take the roll?
Yes, thank you. Dr. Lawrence Adams.
Present.
Dr. David Paris present, and Mr. Raphael Sweet is excused. And you have a quorum.
Thank you. All right. We will move to agenda item 2, review and possible approval of March 22nd, 2023 committee meeting minutes. Is there any corrections or discussion from the committee or any other?
None from me.
Hearing none, I'll entertain a motion.
Motion to approve the meeting minutes.
I'll second that motion. Can we open it up to public comment?
This is Sabina. Can I real quick ask you to possibly amend your motion to include the date of the meeting?
Dr. Paris?
Yes, motion to approve the March 2nd, 2023 committee meeting minutes.
Thank you so much.
You're welcome. Sorry.
And I will second that. Now, if we can go to public comment, thank you.
Certainly. This is the moderator, and we've opened the WebEx Q&A to facilitate public comment. If you'd like to make a comment on these minutes, you may either raise your hand by clicking on the hand icon, or you may look for the question mark icon, click that, type the word comment into the text box, and click send. Each speaker may speak only once and will be given 3 minutes with a 15-second warning. Are there any comments on the minutes? I do not see any comments. Request for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Dr. Paris, will you call the roll?
Dr. Adams?
Yes.
And Dr. Paris is a yes.
Motion passes. Oh, sorry. I spoke too soon. All right, agenda item 3. I'll give time now to Ms. Walker for the update on the board enforcement program.
Sure, thank you. So I just wanted to briefly begin by mentioning that the next board meeting that's scheduled for July 20th of 2023, we've got our planning efforts underway for that board meeting. Something for the committee to keep in mind is that the current statutory provisions that we have that allow us to meet in this form that we're meeting here today, where we have a virtual video conference with no physical locations, is going to expire at the end of June. So we're looking into planning efforts for that July 20th meeting, but just wanted to make everyone aware that we're going to have to revert to the prior Bagley-Keene meeting notice requirements where we can either participate in person, or if we're participating from a teleconference location, it's going to have to be noticed and available to the public during the meeting. So just a heads up on that as it's coming away. We'll be in the coming week or so, we'll get some information out to the board members about that upcoming meeting. I'm very happy to share some personnel updates with the committee. The first of which is that we hired Austin Maha as the board's administrative technician. His first day was May 30th. He's going to be covering the front counter, providing some general office support, and assisting our users with the Connect system with some general troubleshooting. So we're excited to have him on board. We've also recently promoted Tammy Pitto to the board's assistant executive officer effective June 1st. As part of Tammy's role, she's really going to be assisting me with managing the daily operations of the office and implementing the various process improvements that we've been discussing as they relate to our licensing, continuing education, and enforcement programs. As far as legislation that we have, AB 765, which was the bill that would prohibit the use of specified medical specialty titles by anyone who doesn't hold a license as a physician or surgeon, was held in the Assembly Appropriations Committee, and it's dead for 2023. We do still plan to return this bill to the board for discussion of an official position and possible amendments, so that as we head into next year's session, we can communicate those concerns to the author's office and any potential changes that could be needed if that bill moves forward next year. We also have AB 1028, which would remove the requirement for a health practitioner to report to law enforcement when they suspect a patient has suffered a physical injury or caused by assaultive or abusive conduct, and instead provide them with a brief counseling, education, and support, and a warm handoff or referral to advocacy services. This bill has passed the Assembly, and it's currently waiting assignment with a Senate Policy Committee. And this is one bill where we're going to be working with the Government and Public Affairs Committee to put together messaging or potential messaging for the licensees if it was to move forward, so that we can get that information and guidance out on what that would mean when if this bill goes into effect. We also have AB 1707, which would prohibit a DCA Healing Arts Board from denying an application for licensure or disciplining a licensee on the basis of a civil judgment, criminal conviction, or disciplinary action that's based solely on the application of another state's law that interferes with a person's right to receive sensitive services that would be lawful in this state. This bill is currently scheduled for a hearing before the Senate Business Professions and Economic Development Committee on June 19th. Staff doesn't anticipate much of an effect of this bill on BCE because we don't generally encounter these types of cases in our enforcement program, but it does relate to our agenda item that we're going to discuss under agenda item 4 when we talk about what types of discipline by other agencies should be grounds for discipline by this board. So just wanted to kind of put that one out there during my update. There's also before us a Senate Bill 372, which as it's currently drafted would require DCA boards to remove a licensee's former name and gender from the online license verification system and treat it as confidential. DCA has been working on some potential amendments to this bill to really narrow the scope of that process to name changes that are involving either changes in gender identity or in cases of domestic violence, stalking, sexual assault, or human trafficking. And through those amendments, I think it's very likely to address some of the concerns that the board discussed at the meeting in April, and then also the same concerns that have been discussed by other DCA boards. That bill is currently scheduled for a hearing before the Assembly Business and Professions Committee on June 20th, and we will be bringing it to the board for discussion at the July meeting. And lastly, we have Senate Bill 802, which would require a DCA board to notify an applicant in writing within 30 days after a decision is made to deny an application for licensure, whereas current law doesn't specify any time frame. This bill is scheduled for a hearing on July 11th before the Assembly Business and Professions Committee, and we're actually watching it very closely for other amendments that could affect either the board or other healing arts professions. The bill on its face is very straightforward, easy to comply with, but we're going to be watching for any potential amendments to that bill that may include other policy issues. We also have 8 pending regulatory proposals before the enforcement program. 3 of the proposals are with staff. for us to complete the package and submit it to DCA so we can formally initiate the rulemaking process with the Office of Administrative Law. Staff is also updating the record-keeping regulations, the disciplinary guidelines, and the supervision of unlicensed individual proposals based on the policy discussion by the committee at the March meeting. And our plan is to return those to the committee at the next meeting for final discussion. Is there any questions on any of the policy issues that I covered with legislation or regulation?
None for me. Thank you.
Sure. Also within the report in the meeting materials is enforcement statistics. We're at the point in the year where we're heading towards the end of the fiscal year. What we've observed so far is our number of complaints is slightly less than what we observed in the 2 prior fiscal years. There's been a significant focus by the board's enforcement unit on completing our disciplinary cases. As you recall, a few years ago, we made a high number of referrals to the AG's office for discipline, and that really resulted us in peaking at 107 pending disciplinary cases last July. We've got that number now down to 58, and where you see that then come forward is an increase in the number of probationers that we currently have. So we now have 73. And then we're working on improvements to our enforcement program to assign 2 probation monitors and separate that workload amongst staff. We also have 4 strategic plan objectives that are currently assigned to this committee. The majority of our progress has been made in objective 2.1, where we've been discussing updates to the disciplinary guidelines and the implementation of the various CPEI regulations. We've been having the policy discussions at the committee level and really determining the path forward so we can complete those proposals for the full board's consideration. And now that we have the assistant executive officer position filled, we're also going to be ramping up the recruitment process for our enforcement subject matter experts, and with a plan of them coming before the committee for interviews likely in the fall. That concludes my update. I'm happy to answer any questions from the committee about the enforcement program.
Thank you. I had one question, not necessarily about this, but just curious how, do you have an update on how the CE package that we passed at the last full board meeting, if that's progressing or how that's moving?
It's progressing. So staff is drafting that package and we're going to get it off to the Department of Consumer Affairs this month. That one is the highest priority. And then behind that is the sexual misconduct, the minimum penalties for sexual misconduct cases and registered sex offenders. That one will also be going over to the department this month.
Outstanding. Any other comments? Dr. Paris?
No, none for me. I think the addition of Ms. Pitto, and welcome, congratulations. I think we'll go a long way in
Absolutely
moving a lot of these things forward. So happy to see her in that spot.
I echo that. Glad to have that spot filled for you. That's going to take a load off of you and open up some other spots. So fantastic. All right. Moving on to, public comment. Open for public comment.
Thank you. This is the moderator. We've opened the Q&A feature for public comment. If anyone would like to make a comment on the enforcement report program, you can either raise your hand by clicking on the hand icon, or you can look for the question mark icon, click that, type the word comment and click send. And we will call on people in the order received, and we will give each person 3 minutes with a 15-second warning. Are there any comments on the report on the enforcement program? And I do not see any requests. Shall I close the public comment?
Yes, thank you.
You're welcome.
Okay, moving on to agenda item 4, we're going to review, discuss, and possible recommendations regarding discipline against licensees by other public agencies and licensee reporting of convictions, disciplinary actions, and other violations to the board. We're going to amend California Code Regulations, CCR Title 16, Section 304 and 314. And we'll turn the time over to our new Assistant Executive Officer, Tammy Pitto.
Thank you, Dr. Adams, and Dr. Ferris as well. Good to see you both. So as part of the planned Comprehensive Consumer Protection Enforcement Initiative regulatory package that we know as CPEI, the board approved proposed language to amend California Code of Regulations sections 304, which is the discipline by another jurisdiction, and section 314, law violators, and to also add section 317.3, that's licensees reporting requirements. Staff subsequently merged the two sections of 317.3 with section 314 to place the licensees reporting requirements in one single section. Section 304 currently makes the discipline by another state of a license to practice chiropractic in any other health profession grounds for disciplinary action against a licensee by the board. Also, Business and Profession Code Section 141 states in part that any licensee holding a license issued by a board under the jurisdiction of the department, a disciplinary action taken by another state, by any agency of the federal government, or by another country for any act that is substantially related to the practice regulated by the California license may be ground for disciplinary action by the respective state licensing board. So through this CPI proposal, the board was seeking to amend section 304 to broadly make any disciplinary action of a professional license by a state or federal agency or a foreign government grounds for disciplinary action against the licensee. So we're asking the committee to discuss this concept and whether the regulation should be limited to the discipline by another agency that is substantially related to the practice of chiropractic. Also, Section 314 currently makes it the duty of every licensee to notify the executive officer of any violation of the Initiative Act or the board's regulations. The proposed language adds and statutes governing the practice of chiropractic to this regulation. Staff recommends expanding this requirement to include suspected or actual violations, allowing the notification to be made by filing a complaint and establishing a deadline for making this notification to the board. So currently, licensees are required to report any criminal convictions or disciplinary actions to the board on their annual license renewal. Proposed subdivisions B through D of this section would require a licensee to report a felony charge, any felony or misdemeanor conviction, or any disciplinary action to the board within 30 days of the action. So staff is asking the committee to consider whether this regulation should also require licensees to report an arrest to the board within 30 days. So really the committee is being asked to engage in a policy discussion regarding the pending regulatory proposals to expand the disciplinary actions by other agencies that constitute unprofessional conduct and the requirements for reporting indictments, convictions, and discipline to the board, and provide direction to staff. So with that, I'll turn it back over to the committee to engage in a discussion.
Thank you, Ms. Pitto. Appreciate that. Discussion?
Yeah, I have a question, maybe just clarification. I think in the past, whenever we've read Section 314, it was always kind of implied that this applied to any licensee when they were made aware of or suspected another licensee was perhaps committing a violation. So in reading this again, is that the same interpretation, or is this because the 30-day notification seems to reflect like self-reporting? And so I'm not sure if there's some ability to clarify some of the language using terms that identify, that would reflect like any licensee is obligated to the reporting versus some of the sections that specify when we're more implying self-reporting. Does that make sense?
I see what you're saying.
Yeah. And then the second, I guess in the proposed language on page agenda item 4 in the attachment, it notes that essentially the terms any disciplinary action from another licensing entity, etc., or any other jurisdiction shall constitute unprofessional conduct. That seems fairly definitive when we don't know what the disciplinary action was or what it was for. So I think there might be some discussion there. And then the other thing is I think I think we were asked, let me see here. I think the other thing to consider is that it's probably more relative to consider the violation by any agency or jurisdiction, more importantly than necessarily which one is reporting it or enforcing it. I think I heard that we would consider perhaps which jurisdictions or which licensing boards that were only related to chiropractic, but I think the violation could be the more important thing to consider, regardless of where that occurs.
Dr. Parrish, this is Sabina.
Yeah.
I think I might be able to shed a little bit. Hi. I think I might be able to shed a little bit of light on this. This regulation is also like pretty standard across most of the healthcare boards. And so let me give you an example. Behavioral sciences, the therapists, social workers, clinical counselors, educational psychologists, they have a similar regulation that says failure to report to the board within 30 days any of the following: a conviction of any felony or misdemeanor, et cetera, et cetera. Any disciplinary action taken by another licensing entity or authority of this state or of another state or an agency of the federal government or the United States military. And keep in mind too, the board, the enforcement program always has discretion, right? So we're not saying like, a penalty, a penalizing action against them, it's going to be subject to, evaluation on a case-by-case basis, just like every other complaint or any other possible enforcement. But this type of regulation is pretty darn across most all the boards, especially healthcare boards.
So that brings me to my question related to B and C, because you just stated from that board that it says conviction. C seems to go a little bit further, and by subdivision we shall be made in writing within 30 days of an indictment of a felony, the arrest, the conviction, or disciplinary action. That seems to be broader, because I kind of think in terms of, people can make allegations and process. So I'm more comfortable with the statement you made that upon conviction, because a person's entitled to their due process, assuming innocent till proven guilty. Here we're telling them to report within 30 days.
There's another section that was not part of that subsection that I read that also addresses arrests, which is also failure to provide within 30 days of a request. And this just is about documentation of an arrest. And then there's also, this is a very, very long section. So that one is because the board is going to get the arrest record, right, through LiveScan, right? So then they reach out to the licensee and ask for information, because it's just an arrest at that point, right?
Correct.
So this subsection here for BBS, failure to provide within 30 days of a request, documentation to the board regarding the arrest of the licensee or registrant, et cetera, et cetera. So that's also considered unprofessional. We're just talking about what's considered unprofessional conduct because as of that point, it's only an arrest.
So is that more just to inform the board that, hey, this happened, and then the board stands by and maybe checks in with the person periodically to see how things are progressing? Is that what?
I think your enforcement program can kind of speak to how they might handle when they get arrest reports. Okay. Every board handles it a little differently. I know I just spoke with another board, and for example, if there's a conviction and somebody appeals their conviction, everything's kind of put on hold, and there's a status in the Breeze system actually that you can plug in there that basically says we're waiting on an appeal because they're not going to take action until that conviction is upheld. But I'm not sure how your board handles what they do once they get an arrest report. I'm not familiar with your procedures, just a little bit more with my other boards.
Okay.
And I can speak to those procedures as far as so within 314, that's the portion that's talking about like what requirements should licensees be mandated to report to us upon receipt of. So when it comes to live scan, for the most part, we receive notifications timely of when someone's been arrested. Occasionally, we don't get a live scan report on an arrest. So sometimes we don't find out about a conviction until the point of them filing their annual renewal and they say I was convicted, and we're looking through our records and we don't even have a case of this. We were never notified of the arrest. So that would be the benefit, because that was part of the policy discussion, is should we add the notification of an arrest to the board? Once we receive that arrest notification, what we do is open a case on each and every arrest, and then we evaluate what the charges were against the person. If it's certain types of convictions that aren't overly egregious, or it's not something that demands immediate action for public protection, we then we monitor that action. We obtain a copy of the arrest report. We'll give the licensee an opportunity to address the charges, but we would wait until the point of conviction and then pursue disciplinary action if it's even appropriate based on that conviction, if it's substantially related and it's something that the board needs to act on. But if we get notified of an arrest for something that's egregious, like if it's a sexual assault type case or something like that, we immediately refer the matter to the Attorney General's office to make a criminal court appearance on the board's behalf to advocate for some type of license restriction while that person's on bail, whether it's that they be suspended from practice or at a minimum get a chaperone in place or something to that effect. So that's why it's important that we get the notifications, because we make that initial assessment just based on what the charges were filed, whether or not it's something that we immediately need to involve the Attorney General's office, or if it's something that we need to monitor, and when the conviction goes through, if it does, take action at that point.
Well, that answered a whole bunch of questions I had, so that's excellent. Thank you. Item 2, where it says of any felony or misdemeanor, you're not necessarily including traffic violations with that unless they're egregious traffic violations, right? Like a DUI or something along those lines.
I think the regular traffic citations are now called infractions, if I'm not if I haven't lost my mind further. So something has to rise to the level of a misdemeanor or a felony for it to fall under this section.
Okay.
And I also just want to clarify, because when we look at 314 and 304, because that has to do with discipline, we're looking at two different angles. Because with 314, we're laying out what needs to be reported to the board. We still then go through our standard process of actually evaluating what the action was, what the underlying circumstances are, and whether any action is appropriate. But that's where, for purposes of this discussion, we're seeking for this regulation that would require that it be reported to us. But then looking at 304, the staff perspective on that is it may be overly broad in what's being defined as grounds for discipline, because we want all disciplinary actions reported to the board, but then the ones that we would act upon maybe could mirror something closer to what we have with criminal actions, where it's substantially related to the practice, which is also broad, but we have to make the connection. Versus the way this is written right here, 304, just the mere fact that you've been disciplined by any other agency would be unprofessional conduct, and technically you could just pursue discipline based on that. So that's the distinction there. Is 314, we're talking about what notifications need to go to the board's office so we can handle the information appropriately. And with 304, that's the grounds for discipline.
Now that clears it up for me, makes it much clearer. Dr. Paris, any other thoughts or questions, concerns?
Well, I'm supportive. I think 30 days and self-reporting. I do know in the past, even prior to me being part of this board, there was always some questions about, self-reporting versus reporting as a licensee based on, your experiences or knowledge of anything that goes on in the community, the profession. And so I think there's an opportunity to further define what we're really talking about when we say it shall be the duty of every licensee to notify the executive officer, et cetera. When or how we're referring to self-reporting and the mandate there versus, reporting. Is that, something that you may have heard of, maybe secondhand. And I think those are really different things anyway. So I think if we can take the opportunity to maybe strengthen the language by clarifying that a little bit, I think that would be helpful. But otherwise, I'm supportive, I think. I'm sorry, Sabina?
Dr. Paris, I think this might help you. Under 314, if you look at subsection B, it says a licensee shall report any of the following to the board. The bringing of an indictment, whatever, et cetera, against the licensee. So it's referring back to it, his or themselves. The conviction of the licensee, not any licensee, a licensee, it's the licensee. And I can refer to your reg counsel, Stephen, but I'm pretty sure that's the way and the intention. And looking at a bunch of other boards, regs, that's how a lot of the other ones are worded.
Well, maybe I'm misunderstanding you, or I thought I was understanding. You're talking about two different things, Dr. Parrish. You're talking about a chiropractor making the board aware of another chiropractor's actions.
Yeah, I think
that's one thing. But isn't that basically the same as a complaint?
Yes.
So I think we have regulations for complaint. Anybody can file a complaint, whether you're a non-licensee or a licensee. If you see something that's not consistent what you think is appropriate for a chiropractor or any hailing discipline for that matter.
And 314's title is licensee reporting requirements. So it is of the licensee's requirement to report to the board.
Is there another, there's already a complaint section, I'm assuming, right? That's just for anybody to file a complaint with the board on any action that they think is inconsistent.
Absolutely.
So I think maybe we're talking about two different things. I think I see this 304 and 314 as relating to an individual reporting themselves. Either they've been disciplined by another state or military or something, they got to report that. Or if they have done something in their own capacity as a chiropractor.
Correct.
That,
Correct.
kind of telling on themselves in a sense is what I'm saying.
Right. It's the licensee's reporting requirements. As a licensee of the board, you have you're subject to reporting requirements.
Does that clarify it for you, Dr. Parrish, or are you wanting something in this language that does with self-reporting as well as reporting actions that you see in others?
Well, yeah. So two things. One, I just would say that I know with assurances that this has been interpreted in the past by our licensee, our field DCs, as reporting of if I am become aware of a violation of another licensee. This has been interpreted, and if I read the plain language of it, I could see how that's easily interpreted that way. There's nothing that specifies self-reporting. So one, and I know there were some concerns and even positive and negative comments about the profession policing itself, that type of idea with this licensee self-reporting. We're licensees. I am in the best position to know if another licensee is, at least in my opinion, might be violating, regulations, et cetera, right? So I know that that's gone on in the past, and I know I understand this. I mean, but so I'm asking, can we clarify that language, or are we stating that our licensees no longer have that duty and obligation to report those violations? And if they don't, then I don't think it's an issue. This can all be focused on self-reporting and not necessarily, reporting violations in the broader, does that make sense?
Yeah, I understand what you're saying. And I'll let Kristen chime in on whether there is another section somewhere in your Practice Act that speaks to basically tattling on somebody else, for lack of a more professional word, right? When
protecting
can always
the public.
you can always file a complaint, right? You don't need a statute or a regulation to say, hey, if somebody does something wrong and you know about it, you can file a complaint. However, I'm not sure if there's a requirement in your Practice Act that says, hey, if you know a chiropractor did something bad, you have to report it. Kristen?
That's what, sorry to interject there. On the subdivision A, that is, and it's just existing law in 314. That's what the attempt there is with the regulation. It's supposed to be imposing a duty on the licensee to basically, if you see something, report it to the board. But there's, as you can tell with the language, it's not very specific. It doesn't involve like any timeframes for when that report should be made. I can say on the enforcement side, we're not getting a high volume of reports from other licensees. We do get some, like we do get the licensees that report when something inappropriate is going on, but we're not getting a significant volume. And we're on the enforcement side, and this is more of a policy discussion if you want to expand on this, but it's like, ideally, if we're disciplining some conduct that occurred in an office, and it's pretty obvious that the other licensee that was present was aware that was going on, should this be expanded to give us authority to discipline somebody for not making the report to the board? Because right now, with the existing language, it doesn't give us, there's not enough teeth in it for us to really do something if we can show that, they should have known or they should have made a report to the board. So that's where it could either be enhanced, we could repeal it, we can go a number of different directions, but the intent there behind the language was supposed to basically be, if you see something, report it to the board. It says the executive officer because we don't want licensees notifying the board members directly, because you'd have to recuse yourself. You can't be involved in an investigation, but it'd be more appropriate if they just had a duty to file a complaint or notify writing, something to that effect.
And that makes sense looking at the language, how it's referenced, how the licensees, a licensee and the licensee in subsection B. You also can include, I'm trying to find real quick your listing of what's considered unprofessional conduct, but you could, I haven't been able to flip my pages fast enough, but
Section 317, yeah, it's pretty long.
Okay, sorry. But there's also opportunity there, like to learn from some other healthcare boards where they do include aiding and abetting, different types of unlicensed activity, or aiding and abetting, the failure to report, say, child abuse, or the failure to report elder abuse, or, there's, sorry, I'm still, you probably have something close to that in here. It's a long section. Yeah.
I don't know that we do. I would like to see it if we have something close to that. I think this has always been interpreted in two ways. One as a self-reporting, and then one as a kind of the profession, for lack of a better term, policing the profession. And I think a lot of times patients sometimes don't even know about regulatory violations. I mean, unless they're really overt, inappropriate touching, things like that, usually very straightforward. But a lot of times they don't know about it and they end up just leaving an office and going to see another DC. And then the tale's told, during another encounter with the DC, in another office where they're telling them, well, my old chiropractor said this or did this or told me this, and maybe wholly inappropriate. And then, then other conversations can happen. So, but I just don't. So all I'm getting at with this is under 314 is if we can develop language that more fully describes the expectations for self-reporting and 30 days. And then maybe if there's some discussion we have to have about, do we put that 30 days onto our licensees also?
Yes.
I don't know that that's appropriate, but yeah.
I have a suggestion that just might fix that for subsection B. How about it would state a licensee shall self-report any of the following to the board? 1, 2, 3. You just put the word self in front of report. Would that make it more clear for you? Do you think?
Well, yeah, surely that's what I mean. That's partially what I was getting at. So I think one, for sure, we should be identifying the areas where we expect self-reporting, and I don't think we'd expect other licensees to really have knowledge of, these to do it in timely within 30 days. But I do think we should clarify A, which is, the duty of every licensee to notify, the executive officer of any violation of the act, et cetera. I think, I don't know. I'm trying to get out of where are we with this? Is that an expectation of us? Is that something that 314 will continue to carry forward? Because it sounds like we didn't even really necessarily agree on it on this call, that whether that was still a duty or an obligation or not.
And how do we typically enforce that subsection A? I mean, I guess if we find out that somebody's aiding and abetting something, and didn't report it, but their other actions would probably constitute unprofessional conduct regardless.
Well, I mean, this doesn't specify that. This just specifies a violation of the act or of rules and regs. And so, I mean, can we clarify that licensees, where our expectation is that they report these to the board via a formal complaint, something like that. I mean, I don't want to create the language here today, but I think the point is, I just think we can define this better, especially since we're rewriting the regulation. We can make it as good as we can make it.
Well, is it something that we can state very emphatically, like, for example, it shall be the duty of every licensee to notify the executive officer of his or her designee, or and then say something of the effect of or any other licensee in violation of the act. I mean, to just add that language, the self-reporting side, as well as, it's our duty that if we see behavior that's in our colleagues that is not professional, we have to report.
You don't want to limit yourself to licensees only. What if you need to report unlicensed activity? Do you want that to require your licensees to potentially report unlicensed activity? So, because you don't want to limit yourself to them reporting only on licensees.
I think
unlicensed individuals that are working within a chiropractic office?
No, just anybody who's working without a license who should have a license, right? So if you update that language.
Certainly, yeah. I mean, if I know of a chiropractor or somebody who's practicing chiropractic without a license, I'm going to certainly notify the board of that, and I'm going to talk to him myself.
Yeah, but no, I was just. Is
that what you're getting at here, or you're not talking about an unlicensed individual in the office?
No, I was just saying if you added that proposed language into subsection A, you would potentially be limiting. If you added some reference to licensee violations of the act, I was afraid you would be limiting yourself to them saying, "Well, I only had to report violations of licensees, not unlicensed."
Yeah.
Are you following what I'm saying? Sorry.
Excuse me, sorry. But isn't part of our governing practice of chiropractic is practicing chiropractic without a license? Isn't that one of our governing regulations already?
I was just referring to subsection A, 314. I was just with a suggestion. You had suggested some language about possibly adding in the word licensee violation, and I was just saying.
No, I meant other. I meant if we want to clarify that if what we're trying to get across is the licensee reporting requirements. I think what Dr. Parrish is getting at is that the language here is good, but it's not clear. And some might construe from this language that I don't have a duty to report on my colleagues. This is just about self-reporting. And so what I'm saying is that if we change the language that is there that says if we become, obviously we self-report, which makes sense if we within 30 days, so the board is aware of it, or if we become aware of somebody else's another licensee's actions. Is your exception with that? Is that if a person's not a licensee?
Right. That was just this when you said that word. If you added that word right in there, I just didn't want you to limit people's reporting possibly to. Well, I read subsection A and it says I only had a report for licensees, and this guy over here is practicing without a license. He's not a licensee, so I didn't have to report it. I mean, I'm just trying to like think of all the crazy loopholes.
Well, yeah. That's why I'm not an attorney, Sabina.
I was just trying to figure out like, the loopholes.
Because you're right. I mean, it seems straightforward to me, but you're right. There could be somebody out there that's going to take that tack, and I'm not good at regulatory language. That's why I'm a chiropractor, not an attorney. So.
I just don't want you to limit yourself.
Yeah.
I want to make sure that it can be clear at the same time. It's just not limiting or restricting, but it still does what it needs to do and conveys that information. That's all.
And if we strengthen it, but we keep if we leave out just the licensee term, as you mentioned, Sabina, but we still use the sentence, the proposed language sentence of any violation of the act and statutes governing the practice of chiropractic or of these rules and regulations, then I think that would cover us, right? Whether it's a licensee or an unlicensed practice situation, as you mentioned. But I think that language would cover every possible violation.
You could add the word by any individual after violation of the act, or violation by any individual of the act and statutes.
Oh, okay.
That might take care of it all because it encompasses anybody.
So that might include somebody like, that's some of these bone setters, that are basically practicing chiropractic without a license.
Right. So it's anybody that's, what should have a license and they don't, and they're practicing or they're representing themselves or misrepresenting themselves. But if you add the word any individual, by any individual, you might take care of that. I don't know.
Okay.
And that might solve that problem. And then if you add the word self before report, you might solve the other problem. It might be a little bit more clearer.
Yeah.
Just ideas. I don't know. I was trying to figure out all the loopholes.
No, I like it. Can we like if we make a motion here, can we amend the language in the motion, or does it have to go back to staff?
No, you can absolutely amend the language anytime you want. Here, remember, this is just a committee. You're going to recommend it to the full board, and then you guys all can get together and talk about it again at the full board meeting.
Yeah. Okay. I would, unless I don't want to cut anyone off from discussion, but I would make a proposed motion to approve the proposed language for 304 as written, and for section 314 amended to read, it shall be the duty of every licensee to notify the executive officer of his or her designee, comma, by any individual, comma, of any violation of the act. Unless there's better English language, somebody wants to.
I think it should go after, let me know what you think, of any violation of the act. I think it should go after all of that, correct?
By
Not
any
before?
individual. Okay, so put it, let me reread that then.
Yeah,
Fast forwarding to any violation of the act and statutes governing the practice of chiropractic or of these rules or regulations, comma, by any individual, comma, in order that the board may take appropriate disciplinary action.
That sounds good.
That's better. Okay. Sorry, yeah. And then for part B, a licensee shall self-report any of the following to the board.
Perfect. Good
Is
job.
that agreeable? Okay. So that's my motion. Motion to approve the proposed language.
B you're changing to self-report.
Yes, we're adding
And
self-report.
then we're adding any after regulations or any individual.
By any individual.
By any individual.
Oh, by any individual.
And this motion will be a recommendation to the full board. This regulatory language will be recommended to the full board.
Okay.
And may I just ask for clarification on 314, because this is the existing language that we were kind of left off with that we're now discussing and looking to move forward. Subdivision B requires the indictment of a felony, the conviction or disciplinary action, but that old language subdivision C then inserts the word arrest. So as part of that motion, is it to require the report of an arrest within 30 days, or are we deleting the word arrest, excuse me, from subdivision C?
I'm okay with it after hearing what Zabina said, and that's what other health boards are doing. And then after hearing your comments, that my thought process was, people can get, accused of and be arrested for things that are going to get dismissed or are going to not be convicted of, or are going to be, and what might that do, and you clarified that for me, that depending on the level of the arrest and what it involves, how much it in how it relates to protection of the public. Particularly, my concern was, in the case of allegation of sexual misconduct, that then you're saying that it has to go to the Attorney General and evaluate the nature of that and determine whether a chaperone or suspension, that it's just not kind of, hey, you got arrested, you got to stop practicing for 30 days while a person's trying to defend themselves and their livelihood is being affected. It sounds to me, through your clarification, that there's a process that it goes through before that happens, so that a person is getting their due process appropriately.
Correct. Yeah, and the intent there behind requiring the arrest within the notification of the arrest within 30 days is really just to catch any circumstances where the live scan fell through and we didn't actually get the notification. It's really to make sure that we have the information we need. We don't always immediately act if it's not a substantially related conviction or arrest. We have the record, we actively track it as part of our case management activities, and we act upon a conviction just as we would if they reported at the conviction point. It's just making sure that we're aware
right
in advance.
Yeah. No, I'm like I said, I'm comfortable with the language after hearing Sabina and you explain, the process. I'm still learning that process. I'm as I go here. So I'm more comfortable with the changes we've made. Dr. Paris, any other comments?
I do. I have one more, and just a clarification or question. So it seems to me we have B, and why can't we just put the plain language in C into B? And it seems like we're repeating the list um, other than the arrest language that you pointed out. It seems like everything else is included in B already. And why can't we just put the self-reporting, that it shall be made in writing within 30 days, and then we can include, the arrest language under 1, 2, or 3 in B. In other words, why did we split those off?
So this is, I can't speak to it too much. The language itself is pretty old. I would say, but in both sections, there's definitely some room for just improvement and clarity in the language. Yeah. That's the stuff that, so we need the policy direction from the committee, and if you want to bring it forward to the full board, and then we take it offline with our reg council, and then we clean it up and we make sure that the intent is still there, but we try to make it easier to read. So we would do that in this case. Like, you don't have to, not expected during this call to get all of the language itself correct, as long as we just know what the direction is, so we can put it together and bring it back in final form.
Yeah. Okay. So, I mean, then I guess other than I'll keep my motion as is, knowing that there'll be some cleanup coming back to the full board along with the
Absolutely. Yeah.
motion with the amendments. I'll leave it as is.
I agree. Do we need to restate that motion, Ms. Knight?
It's up to you if you would rather. I can redo it if you'd like, but we have the motion on the floor to recommend to the full board the language as presented in section 304 and 314 with the modification of adding by any individual after the word regulations in subsection A and adding the word self before report in subsection B.
I'll second that motion.
We're going to second and third it all day long. Awesome.
I have no other comment discussion.
Good. Did you say you have more, or you're done?
I do not. I'm done. Thank you.
Oh, okay, great. Well, we have a motion. We've got a second. So if there's no further discussion, if we can open this up for public comment.
And we have opened up the WebEx Q&A feature to facilitate public comment. Anyone may comment on the motion by either raising their hand, by clicking on the hand icon, or clicking on the question mark icon, type the word comment and click send. Each speaker will have 3 minutes with a 15-second warning, and speakers will be allowed to speak only once. Our first raised hand is from call-in user 2. I'm going to send a request to unmute, and you can use *6 to unmute yourself. You're unmuted.
Hello, this is Falcon Lumont, student intern from Chiropractic College West. This is regarding a separate section. During the Board of Chiropractic Examiners California Licensing Committee meeting on May 12, 2023, the agenda item that involved the BC rule edit for the rules and regulations section 231.12.2.e for the Chiropractic College curriculum to include
Excuse me, sir. Excuse me, just real quick. Do you have a comment on the agenda item 4 that we were just discussing? We have another agenda item for items not on the agenda.
I was just reading that this would be about disciplinary actions, suggesting disciplinary actions for possible other violations to the board. That's why I chose to include this comment here.
Yeah, so if you have a comment about the items 304 and 314 that have been put before the committee for a motion, if you have a comment about another committee meeting or for another agenda item, things not on the agenda, that comes at a later point in this meeting. Okay. So we'd ask you to reserve your comments for them.
Yeah, I'll reserve it for another section. I would just this item said other violations to the board, so I thought that this would be an appropriate place. But I'll wait for another agenda item here
Okay, thank you. Yeah, we've got a section geared towards items not on the agenda, and we'd be happy to hear from you then. Thank you. Is there any other public comment?
Yes, we have a commenter logged into WebEx as ML, and ML, you are unmuted and you'll have 3 minutes.
Thank you. Hi. I just wanted to say, I'm not sure which code number this was, but I wanted to say that it's very important to always include unlicensed activity, or those who are on probation, or those who have been revoked, because these people who are committing misconduct, or who have been arrested, they will find loopholes. So it's important to acknowledge, and thank you, Sabina, that there are loopholes, and to make sure it's inclusive, always inclusive of present licensees, revoked licensees, prohibited, those on probation, and those who are practicing, who never even had a license. Thank you.
Thank you for your comment.
And I do not see any other requests for public comment. Shall I close public comment for this item?
Yes, thank you.
You're welcome.
Any other discussion before we proceed? Okay, hearing none. Dr. Paris, would you call the roll for the motion?
Yes, Dr. Adams.
Yes.
And Dr. Paris is a yes. Motion passes.
Thank you. Appreciate that. Okay, moving to agenda item number 5. Review, discussion, and possible recommendation regarding the filling and evaluation process for petitions for reinstatement, reduction of penalty, and early termination of probation. Amend CCR Title 16, Section 365, and add CCR Title 16, Section 385. I will now give the time to Executive Officer Walker for her report on this agenda item.
Sure, thank you. So the purpose of this agenda item is really as another one of the pending proposals as generally part of the CPEI regulations, was to establish regulations on the petition process itself. So really what we're going to be asking the committee to engage in this afternoon is a policy discussion on the petition process, and what types of, what that process should look like, and what types of requirements would the committee and ultimately the board like to see in effect before someone's qualified to be heard before the board. So first off, beginning with continuing education requirements. Currently, the only real gatekeeper that we have for when someone is eligible to be heard by the board is if they've been revoked. There's Section 365 that requires that they complete continuing education, and then we have application fees. So with 365, what that currently requires is for someone whose license has been revoked, and we of course would be expanding that to also include been surrendered, that they complete the CE requirements for each year that their license has been revoked. As we've observed, sometimes that means they're taking 20 years worth of CE just to be able to be heard by the board. And then there's the issue that we've seen where they take the same CE courses multiple times so that they can hit that high volume requirement, but it's not necessarily demonstrating any additional rehabilitation or any additional skill that would make them relevant for getting their license back. So for purposes of the policy discussion on continuing education this afternoon, the Continuing Education Committee had previously discussed the issue. They amended into our current continuing education proposal that you don't get credit for repeating a CE course when we talk about the annual renewal. But then they deferred the discussion of how do we handle petitioners to this committee. The kind of what was talked about at that meeting left off with setting a maximum of 4 years worth of CE for, kind of setting a cap so that 40, or I guess, don't want to do the math on the spot, 96 hours would be the maximum. And then they also had talked about requiring part 4 of the examination. the national examination if somebody has been revoked for 5 years or longer. So we want the committee to engage in that discussion. Some direction that staff needs. One is if that's the direction this committee would like to go, but then also where would the placement of that Part 4 examination requirement fall? Would it be something that they have to take it before they can be heard before the board, or should the regulation require that if their license is reinstated, it would be reinstated with a condition precedent that they must take and pass that exam before it can be reinstated? So there's different options that we can consider there. If we're looking at something along the lines of they have to take that exam before they can even be heard at the board, then we would also need to discuss what that looks like for them repeating it. If someone took an exam and they're continuing education, they were heard by the board and denied, and they want to reapply, do they have to take it again? What does that look like? So that's the policy discussion on continuing education. Then we've also provided some samples from other boards in the meeting materials. And we've got a couple other ideas that we had just thrown out to share with the committee on really enhancing that petition process. There's things that the committee could consider on what the criteria for when you're eligible to be heard. Looking at some of the other boards, they don't hear petitions by people that are still currently under sentence for any criminal offense. And they also don't hear any petitions by someone who has a pending accusation or petition to revoke probation pending against them. We don't currently have that criteria in effect. So, I mean, we could have somebody that, actively has a petition to revoke probation because they're not complying with their terms and conditions, and yet we still have to give them the opportunity to be heard before the board on why, potentially they want to be removed from probation. So that's one thing to consider. The other thing that we thought was really good when looking at the other boards was the way they summarized the use of a narrative statement to accompany the petition. A lot of times it's not clear when we're evaluating these petitions. It's like, what is it specifically that you're asking for the board? How have you demonstrated your rehabilitation? What are your plans for practice after, if you were to get your license back, or if you were to be, removed from the probation program and given your full license back? So there's things there that we could enhance, and that's and incorporate as part of this process. There's also one thing that we saw commonly with looking at the other boards is that they require a minimum of 2 verified recommendations from other licensees. And the key word there with verified is not only are they requesting that it be provided, but the staff, as part of the process of preparing for the petition hearing, contacts those individuals directly to confirm that, yes, they wrote the letter, yes, they're aware of the action, just so that it's been verified and we know that those are at least two solid recommendations that go along with it. And another one, it's more administrative in nature, but we do need to establish some sort of process for handling what happens when someone abandons a petition. Occasionally we do receive petition applications where they're either missing their continuing education or their fee, and then it just becomes an open file because we haven't formally put anything into effect of considering it abandoned, shredding it, and moving on. So we were kind of proposing doing something similar to what we do with a license application, where we have a 1-year period, and if they don't complete the requirements, it's considered abandoned, and we get rid of the application. So number of different items for discussion. You don't have to go point by point, but we just wanted to put this back before the committee to have a policy discussion on the petition process, some of your observations and things you'd like to see improved that we can implement into these regs. And then, of course, having the discussion on continuing education as it relates to these petitioners.
Thank you. Very thorough report. Yeah, I liked where this is going. I love the proposed language, quite frankly. So I don't really have a whole lot other to say. I think it's really well put together. I commend you and the staff for your efforts in bringing this to us for review. So I think it looks good. Dr. Paris.
Yeah, I like the medical board's petition form. I think it's really it's really kind of instructional to the petitioner, and it kind of lays it out in a really nice, I think, fairly easy way to kind of walk through it. I think a year is probably plenty of time to have petitioners complete the requirements. So if that's what staff had in mind as an appropriate time frame, I'm supportive of that. I like the letter of recommendations. I think we should add that. I think that's really valuable, including the language of declaring it under penalty of perjury. And what was the other?
Part 4.
Oh, part 4.
Time frame. I forgot to comment on that. I'm definitely in favor of that. I've kind of floated that a little bit as I've been teaching the last few months, and there seemed to be a lot of like, whoa, man, I don't want to ever do anything wrong because I don't want to have to go back and take those. And the fact that part 4s is those that have taken part 4s know that you have to be on top of your stuff. So I personally think that I like that idea that we floated before about whether it was 4 or 5 years. I can't remember. I think it was 4 years, that anything beyond 4 years or 5 years of not having your license, of a revoked license. I think that makes sense, to do part 4s. They're certainly going to have to do close to 96 hours of studying to pass part 4s. And I think that's a better use of their time than just sitting through some of these CE classes that sometimes they're not really participating in.
Yeah, I would agree with that, and supportive of having them take part 4 again. And then also, I think in regards to the timing of that, I think you mentioned, I think really it would be more beneficial to have us reinstate and then give them a time frame, give them 6 months or a year or something to pass part 4, within that reinstatement. And I just think it prevents us from having the licensee, and from us having them perhaps have to retake it, as you mentioned, or if they have to come back. I would be more supportive of seeing them, giving them a time frame after reinstatement to pass part 4 than to have passed it prior to, getting a hearing.
Yeah, I think along those same lines that my first thought was, well, that would be a good way for them to show us that they're really serious about it, to do it before we have the hearing. But then the thought that they would do that and then get their hearing denied, and thinking, but at the same time they are doing their continuing education before they're eligible to come before us. So we could make a case for the fact that, rather than, think about it, if they're having to do 4 years of continuing education, the cost that they would have to spend on that is probably going to be close to what the cost of part 4s is, and the study required for that. You can make a case either way for them to have to do part 4s before they're eligible for the hearing, because we're having them do their continuing education before they have the hearing as well right now. And many of them get denied, for other reasons.
Yeah, I think part 4 is probably the bigger effort, for lack of a better term, probably more studying, more preparation, maybe separate from a lot of the continuing education courses they might take. And I think that it would be more appropriate for us to make sure that given all the other all the other reasons that they may or may not get reinstated, that they get reinstated, and then we can have further assurances by saying, okay, within the next 6 or 12 months, you pass part 4. I mean, I would be comfortable with that. I do see the side where I'm kind of speaking against a little bit against like the ultimate in public protection if we were really being, hyper focused. But I think the burden on the licensee to get all of that in just to qualify to sit for a hearing is, I think it's a little too much. So I would I kind of lean towards allowing them time, you know, and I think a lot of preparing for part 4, there's a lot of value in actually being in practice while you're preparing for part 4. You know, there's some congruency there in prepping for part 4 and reviewing clinical things that you'd be studying and preparing for part 4 before you were actually able to, you know, kind of experience those things again in practice and put your hands on and stuff. And part 4 has a lot of congruency with, you know, being in practice and being able to engage in the profession again.
Well, it's something that came into my mind is the fact that, you know, if we're dealing with somebody who's got a revoked license, they can't even take part 4s until their license is reinstated with conditions. So it would have to occur after they get their license reinstated. Whereas,
okay,
am I correct in that a person that's got a revoked license, they technically don't have one. So when they're taking continuing education, they're probably just utilizing their old license number to take those courses. But the likelihood is it. What's that?
Oh, sorry. I'll go on mute.
Oh, so I mean, I'm just clarifying there. I think, yeah, that makes sense. Are we talking about, though, as a discussion on this further, are we talking about a situation where they're going to do both as a condition of their reinstatement if they're beyond? I mean, we should set up, for the benefit of the staff, a time frame that we're comfortable with, that we can bring to the full board of what, because we talked about this and kind of kicked it over to this committee as it related to reinstatement, is what time frame? Is it 4 years, 5 years? If a person is less than 5 years, do we just have them do continuing education to get their license reinstated? Or, you know, and if it's more than 5 years, because we've had some people come to us with, you know, 10, 12, 15 years of not even practicing. So I certainly think they should be passing part 4s if they're really serious about it. That, to me, is the ultimate in public protection, is having them repass part 4s. So perhaps, you know, giving the staff direction, I mean, I think 5 years. 5 years is a long time to not practice. I think, you know, 5 years or more, part 4s make sense. Perhaps less than that. You know, just complete their continuing education, as long as they're not repeating the same course every 3 days.
Yeah, was the previous, was it agreed? It was 4 years?
I can't remember if, I think we were kind of bantering back and forth 4 or 5 years. I think either one would be fine. More than 4 years, part 4s, less than 4 years, continuing education completed. I'm comfortable with either one.
And
excuse me, but the way I believe the way staff interpreted that discussion was, it was at the official record was at 4 years, but it could, you know, 5 makes sense as well. But it was establishing a cap so that if your license has been suspended or it was revoked for 7 years, you would complete, you know, up to 5 years of continuing education plus part 4. It wasn't like an either or. It was like you would do both, but it would cap it. So if you've been revoked for 3, you only have to do 3. But if you've been revoked for 10, you're looking at like 5 years of CE plus part 4. To the point of, you know, being outside of practice for a certain amount of time, that's where the condition precedent would be an effective option, because what that does is if the board decides to grant a petition, you do what's called a condition precedent, where right there in the decision, it says that, you know, the petition is granted, you know, prior to the reinstatement of their license, you know, they shall take and pass the part 4 exam, you know, within a year. And then, you know, upon passing that, then the license will be reinstated, placed on probation, and you put all the terms. But you put that right out there ahead of time so that they can't practice until they've demonstrated competency by passing the exam. That's one mechanism you can use, or you could just immediately reinstate the license with some sort of term that says over the next year you need to pass this exam. But if the concern is with competency, the staff recommendation would be to establish the condition precedent where that you're not going to allow them to practice until they've passed that exam.
Well, my personal feeling is that I see the value. I think Part 4's is current. I think that's kind of what I'm getting at is I don't think they would have to do 5 years of continuing education and Part 4's. I think Part 4's would cover that continuing education because that's going to bring them up to current practice and principles and those things that are being implemented by the NBCE and what is being taught, in the schools in a sense. So I would be okay with, if they're more than 4 years, suspended license, past Part 4's, we would probably need to check with the NBCE to make sure that they're going to allow someone that has a revoked license to sit Part 4's as part of the condition of their reinstatement. I'm sure that NBC, has a consideration for that. And then continuing education for, less than 4 years. I don't see the benefit, really to having them do, 5 years of continuing education and Part 4's. And yeah, I mean, that would seem to be, overkill in a sense, because Part 4's is pretty thorough on things.
Well, except that Part 4 is really, mainly the clinical, like physical exam technique, has some case management, and doesn't cover a lot of kind of some of the mandated CE categories that we would have. And so when this initially, if I recall, when we initially started discussing this, we always knew that we wanted, petitioners to do continuing education. And the question was, how much was enough when they haven't practiced for a lot of years. And then we had some petitioners that brought up some questions of clinical competency, but they were always kind of a little bit separate. In other words, we knew there was a need to get caught up through continuing education and all that different subject matter, and but having the clinical competency was kind of a totally separate and distinct concern. And so I think that's where we were discussing that was, we still wanted the CE. We were just going to say, okay, when do we feel comfortable that there can be a cap that, now they're just doing CE to do CE,
Right.
And then second, and how much was enough do we, for public protection there? But that covers a much broader range of categories. There's really no ethics on Part 4, right? There's a lot of categories that aren't even covered in Part 4, and it's really a hands-on station to station test, of their abilities to, think clinically and actually perform, physical exam and orthopedic tests, et cetera. So to me, they were always separate and distinct. So I think they're still both extremely valuable, just a little bit of a different consideration with the cap versus at what point do we feel like providers should go back and demonstrate their competence, in their hands-on skills, their physical exam skills. And then I just have one other question. So that's my thoughts, that we still would mandate them both, because I don't think Part 4 ever covers 4 or 5 years of CE.
Right. Well, okay. Well, yeah, that's a good point on the competency side. Can I, before you ask your next question, can I just jump in though real quick? And that was, I thought as usually most people, when we have them reinstate after they've had their license, don't they have to pass, jurisprudence, and don't they have to pass some of the other tests that are associated with the practice? Okay, we make that a condition of their getting their license back, which is in a sense requiring them to pass, ethical boundary aspects and jurisprudence aspects and that. Because certainly the three of the competencies, right? You've got evaluation management being handled by Part 4, you got technique being handled by Part 4, and you've got diagnosis, evaluation, and documentation being handled by Part 4. It's mainly the ethics isn't part of Part 4. Correct? Is that your understanding?
Oh, go ahead.
I'm not sure. Do you mean are you saying you feel like it covers all of their CE? Like we don't really know. I think the part of my concern would be too, we don't really know. I think having CE and making sure that they've done so much CE is our assurances that we've set a number of hours in a certain number of categories and they've studied this broad range of knowledge to re-enter the profession. And when it comes to part 4, we don't really know. They could go take a part 4 review and pass. And that's like 2 or 3 weekends, right? If that, maybe. So, like, we don't necessarily know that they've done, how much studying they've done, other than they just passed part 4.
Well, I'm just thinking about, part 4 is the minimum competency to practice chiropractic. That means that basically we're saying that they're safe. Correct? That's my understanding of minimum, the NBC is evaluating them to, are you able to practice the chiropractic? Do you have a knowledge base, technique base, to practice chiropractic and be safe? If we don't have that opinion of part 4s, then maybe we got to reconsider whether we're going to accept part 4s for our new licensees. That's all I'm saying, is that in those areas, and then having them take ethics or past jurisprudence and pass part 4s, if we're saying that's good enough for a new licensee to show their minimum competence and their understanding of the rules and regulations and the ethics and law, why would we have that be different for someone that's for reinstatement if they show that they're properly rehabilitated for what they got their license lost for?
So part 4 generally covers the diagnostic imaging, case management, and then technique. And the case management includes, ortho, neuro, physical exam, testing, etc. But I think the difference is that we're talking about unlicensed providers who have done nothing for the last 4, 5, 10, 12 X amount of years. And we're talking about students who are getting out of a 3-year academic full-time program, and so and they pass part 1, part 2, part 3 to get to part 4. So I think we have a lot more assurances. I don't know that they're equivalent necessarily, because those are students who are at the end of a doctoral educational program, and now they're taking the tests you mentioned, et cetera, license, jurisprudence, and part 4. But they had to go through a lot of clinical testing in school to get to that point. They do a lot of on-site testing courses, classes, and all those subjects, and then they did part 1, part 2, part 3, and so I don't know that they're necessarily completely equivalent in my eyes.
Okay.
Yeah.
Well, that's why it's good to have a discussion. I'm comfortable with. So I guess maybe what we need to do is set a cap and a time frame for staff. So why don't we address the time frame first? What are you comfortable with? I like the idea of 4 or 5 years. I'm okay with that. Pre-5 or post-5. What would be a good cap?
I think if I could just ask one question, because it'll help me answer that. So Kristen, you mentioned when you were describing the ways that it could be applied, is that we would always retain authority that would be optional, or would this mandate it after a certain number of years, and then we would just pick the timing either prior to obtaining the hearing to qualify for the hearing, or if we could put it in so that we reinstate your license and you have 12 months to pass part 4.
So you have the flexibility to put that into effect in whatever way is appropriate. For purposes of the discussion of having to put together regulations on the petition process, 365 really, it makes staff a bit of a gatekeeper because the way it's worded about any person making application shall be required to fulfill. So that puts as part of the staff review process of the petition. We're for years it's been since they've been revoked. We're double checking all their CE, making sure they've met that requirement before they can even get to the board level. You could continue doing that with setting a cap, up to 5 years worth of CE, and then staff would retain being the gatekeeper of no one's going to go before the board until they've met this regulatory requirement. You could also put that type of gatekeeping effect with the Part 4. You could put it right there. You could say that shall be required to complete up to 4 or 5 years of continuing education, and if the license has been revoked for over 5 years, demonstrate passing Part 4 within some set time frame before making application. That would make, again, staff the gatekeeper. It would then make it required for anybody that meets that criteria that they do it. The other option is, you could pare down the continuing education, keep it with staff as a gatekeeper, and for the Part 4, you could, the board has discretion. The board can do whatever you want to put in any petition decision as it is. So the whole idea of Part 4 and that consideration and discussion can really be incorporated into disciplinary guidelines. You can put a guideline in effect that generally the board will, impose these types of conditions, but then you still have discretion and authority to, make any type of deviations if it's appropriate. If someone's demonstrated competency and you don't question it, it's not necessary. So that whole discussion on the examination component can be moved to disciplinary guidelines unless you want to make it mandatory and you want to have it clearly in a regulation. Or otherwise, we can move that whole discussion when we get to disciplinary guidelines and just establish continuing education. Unless you want it mandatory across the board, then we would put it in a regulation that just states for a fact someone shall do something.
Understood.
I like that.
Thank you.
You like that, Dave? You like that, having a little more discretion?
Well, I like the discretion. I think it in my mind, then it allows me to think more along the lines of like 5 years, then it becomes mandatory versus 4, I guess, if we're ranging that somewhere in there. I think that if anyone hasn't had a license and hasn't practiced in 5 years, that we can make, we can say, you have to retake Part 4 to practice again. And then, so the question, Kristen, would be, do they do that to apply and before it comes to the board, or do we have the opportunity to then say, we'll allow you to come to the board, but if you've been, revoked for 5 years, the expectation will be that if your license is reinstated, we will require you to take Part 4 within the next 12 months, take and pass Part 4.
Yeah, you could put, if that's what you're envisioning, that it's required that you demonstrate the CE just to be heard by the board, we would have 365 to that effect, and we would put the intention there that generally, if it's been 5 years since you've been licensed, it's appropriate for us to insert this type of condition in any order granting reinstatement. We would put that in disciplinary guidelines. And then just like it's a guideline. So when the board's considering during closed session, you have that tool available to you, and then you can discuss whether or not it's necessary for those specific circumstances versus regulation where you've already made your decision in advance. So it sounds like we can kind of, for a bit, we can table a little bit of the examination discussion if that's going to become part of disciplinary guidelines, because we have quite a bit of kind of guidance on that one. And if we could just set a level for the continuing education that's going to be capped before they can come before you.
Right.
I like that. I like that.
So Dr. Adams, what would be your thoughts on capping the CE then? 4 years, 5 years? I think we were at 4 years before, which was it was at 96, right? Am I doing the math or something?
Yeah, I mean, I could go either way. I mean, I'm fine with 4 years. 4 years of continuing education, 96 hours of continuing education is I think, pretty good. And I like the idea of having the discretion that we put in there as part of our disciplinary guidelines, is that if it's beyond 5 years, there's a strong likelihood, and just putting it in there as we do with the other disciplinary guidelines.
Yeah, I like that too. The only suggestion or question I'd have is, then can we mandate the CE 96 hours with the, will the language reflect that it also contains the proportionate amount of mandated CE? So in other words, it's not just 96 hours, right? They would still have to do, let's say the regulation passes and we have 10 hours mandated, then they would have to do the appropriate percentages of that subject matter.
Yeah, that's how we apply it with the being required to fulfill the continuing education requirements for each year, up to a maximum, and we'll make sure that that's reflected in the language. And then I don't think there's any opposition either to having the language not for that 96 hours, not allowing any repetition. It has to be 96 unique hours, no repeating the same course to add up to the total.
Absolutely. Okay.
And what you were getting at, Dr. Paris, was the fact that they still have to do the 10 hours a year of the, based on the new CEs, they have to do the 10 hours. They can't just do 96 hours. If we go with 4 years, they got to have 40 hours of mandated. Is that what you meant?
Yes.
Yeah.
That's what I meant.
I totally concur with that. Yes.
Because I think we were starting to see some of these longer courses where, anyway, I just think that's in our best interest. So, yeah. And I like I like that no repeats.
Yeah.
Yeah. Okay, I like that. Is that good? Was there another question in there?
The only other one that I'm seeing is if there's interest in the committee in prohibiting anyone from being heard if they're under sentence for a criminal offense.
Yes.
That applies not only to somebody for reinstatement, but also like if a petitioner, we put them on probation for, a criminal offense, it would prohibit them from being able to come back and petition the board for modification, or maybe you just restrict them from being able to apply for early termination of probation because we're monitoring them. So we can explore that a bit further if there's interest there. I think, and then the other one had to do with, if we filed an accusation or petition to revoke probation against them, not allowing a probationer to petition before the board, they should potentially could just be disqualified.
I think if they have an active accusation or whatever you laid out there, I agree with that. If they're on probation or under probation for another criminal offense or any of those that they should not be considered for application.
Yeah, I 100. I agree with that completely. Yeah, they should come. I mean, I hate to, for lack of a better term, it should be a clean slate when they come to get reinstatement.
I concur. So just to bring it back around, I think our suggestions to staff is we're looking at the guidelines for Part 4s when someone has been beyond 5 years, and 96 hours as a cap for continuing ed, with completion of all mandated requirements for each year. Is that what your understanding is, Dr. Paris?
Yes. Yes, it is.
Okay. Ms. Walker, need anything else?
Nope. We've got plenty of direction here to bring it back and put together a complete proposal for I would suggest possibly we could go about it one of two ways. We could bring it back to this committee, or we could bring it directly to the board. It's kind of your preference, but we have plenty of direction, I would say, here. There might be some additional details to sort out, but overall, I think we have what we need from staff.
Well, I think Dr. Paris and I both agree that what you laid out as, the new language that you put for 385 we like, and then just clarifying those points for you. So if there's a motion that we need to make, can you restate that for Dr. Paris and I, or is it just now we've given you suggestions and now you can go back and then bring it to the full board? What do you need from us today?
This is Sabina. There's no motion required. I think there's, it sounds like there's a lot of great input that's been given, and the staff has been taking those notes, and they're going to try to find a way to rework that. Did I miss anything, Kristen, or anybody else?
No, that was clear. I guess I was just trying to clarify from the committee if you want it brought back for an additional policy discussion, or if you want it cleaned up and just when it's ready brought to the board. Whether it's July or maybe October.
Yeah, I think Dr. Paris and I are in agreement with the changes that we suggested, or the caps and suggestions we've given. That the other language is ready, in my opinion, and I think Dr. Paris as well. That I don't want to speak for you, Dr. Paris, but I think we're in agreement that we're ready to have, with those corrections that we just discussed, or those additions and clarifications, to bring it to the full board.
Yeah, that was the question. Do we need a motion to just move it to the full board? And not
right, that's what I was wondering.
You can do some sort of a motion if you would like to state that you would recommend this language pursuant to all the suggested changes and updates to be taken recommended to the full board at the next full board meeting.
I would make a motion as stated by Ms. Knight. Recommend the language be the suggested language be moved to the full board.
Right, with the proposed updates and any other technical and other type of updates the staff makes.
Yes, with proposed updates and other technical language edits the staff may make.
I'll second that. Is that clear enough to everybody? And in what we're attempting here with this motion? Do you need anything else, Ms. Knight?
I think I'm good with it.
Okay, so I will second that. So if we can open up for public comment, agenda item 5, thank you.
Certainly, and we've opened up the WebEx Q&A feature to facilitate public comment. If anyone has a comment on the motion, you may look for the question mark icon, type the word comment and click send, or raise your hand by clicking on the hand icon. And our call-in users can press *3 to raise their hand. Each speaker will have 3 minutes. And I do not see any requests for comment on the motion. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
If there's nothing further, Dr. Paris, if you'll call the roll for agenda item 5.
I will. Dr. Adams?
Absolutely.
And Dr. Paris is a yes. Motion passes. I do
Thank
have
you.
one last comment, if I can.
Yep.
Sorry. So I don't know if it's a consideration then that that we may consider developing a document much like the medical boards, kind of in the content and look.
Yes, yeah, we're gonna clean up those forms. They're not gonna come back even close to this when we bring it up to the full board. We're gonna make those changes, and then we're also gonna discuss with legal counsel whether or not to formally incorporate them by reference or just put the requirements in the regulation. So we'll work on that offline ahead of the board meeting with updated forms for the board to consider at the meeting.
Perfect. Thank you.
Sabina, do we need to reopen?
No, you took your public comment on the motion, correct? So
We did.
yeah, your vote, you're good to go.
Okay, great. Okay, moving on to agenda item 6. This is public comment for items not on the agenda. Members of the public, please remember to address the committee. When you address the committee, we advise you that the public, you may identify yourselves voluntarily with your name, and if so, it'll be recorded in the official minutes. but you are not required to give your name. Please open for public comment.
Thank you. And we have opened the WebEx Q&A to facilitate public comment for items not on the agenda. These items may be considered for a future agenda, but discussion will not occur today. We do have 2 raised hands. The first is from someone logged into WebEx as ML. And ML, I'm sending you a request to unmute. You'll have 3 minutes. And you're unmuted.
I just want to confirm this is for public comments not on the agenda, not future agenda, right?
Correct.
Okay, so I'd like to comment that I understand the board is working on regulations for supervision of what services unlicensed individuals, which include revoked licensees, can perform in a chiropractic office. I would also like to see these policies included in an integrative office where a chiropractor who potentially works there, if their license was revoked. I appreciate these guidelines and regulations being developed. Thank you.
Thank you.
And our next request for comment is from calling user 2. I'm going to send you a request to unmute, and you can press *6 to unmute yourself. And again, you'll have 3 minutes. And you're unmuted.
Hello, this is Falcon Lamont, student intern from Northwest. During the Board of Chiropractic Examiners California Licensing Committee meeting on May 12, 2023, the agenda item that involved the VC rule edit for rules and regulations section 331.12.2.e for the chiropractic college curriculum to include a partial point for the doctor tiered order that involves the detection of subluxation evaluation and its measured data that finds no subluxation detected and therefore no need for a subsequent adjustment force on the patient was discussed. However, no actual progress was made for it by the committee during the meeting. It was only a continued discussion, and I fear that that might be the only update that will be given to the BCE full board at the July 20th, 2023 teleconference for an item that the BCE chair and vice chair already gave approval for the rule edit bill last year, October 2022. I humbly request that the BCE enforcement raise concern for this implication. If draft language for the rule edit isn't made available for July 20th, then I beckon that it be deemed as a symptom within the BCE licensing committee as a betrayal of the trust of the Attorney General and the Attorney General's responsibility to uphold the interest of the public safety. Without the rule edit, the public is exposed to the toxicities of chiropractic over-adjusting, and the public is also falsified from the known fact that no actual additional benefit is had from breaching the chiropractic adjusting treatment limit. There is currently nothing in the BCE rules and regulations that hold the student intern at the college clinic level accountable to prevent that, all at the expense of the public patients who participate at the California College Clinic. How then does a doctor-patient relationship proceed without breaching the limits and isn't via a sub-doctor tiered order? It is a line of trust already kept as an available option with the Department of Health and Human Services, the Veterans Health Administration, the Council of Chiropractic Education, Life Chiropractic College West, and Health Insurance Code CPT 99213, the doctor tiered evaluation that detects for chiropractic subluxation. It yields more benefit for the patient than the patient not meeting with a doctor at all. It is only the BCE that withholds the student intern from proceeding with this public practice option. Public practice options should be just as available as private practice options at the root level, the college clinic. If the draft language for the rule edit isn't made available for the July 20th full board
15
to
seconds.
vote into legal counsel submissions, and I request that some of the members of the licensing committee be reassigned so as to prioritize the trust the Attorney General has given to the chiropractic profession within California to uphold the interest of public safety before proceeding with the interest or anything else.
Thank you. Your time is up. And I
Thank you
do
for your
not.
comments.
I do not see any other requests for comment. Shall I close the public comment field?
Yes, thank you.
You're welcome.
Okay, agenda item 7, future agenda items. Dr. Paris? Did we lose?
I
Did
don't
we
have
lose Dr.
anything.
Paris?
Oh, can you hear me?
Yeah, I can now. Yes.
Oh, okay. I'm sorry. It was, yeah, I don't have any future agenda items. Thank you.
Nor do I. So if you would open for public comment.
Certainly, and we've opened up the WebEx Q&A to facilitate public comment, or anyone may raise their hand to request a comment. And I will recognize one hand raised from ML. Again, sending you the request to unmute. You're unmuted. ML?
Yes, can you hear me?
Yes, now we can hear you very faintly. If you could project a little more.
Oh, can you hear me?
That's better. Thank you.
Yes.
Thank you. Okay. I'd like to submit several future agenda items. 1, discuss or legislation changes regarding implementing interim restrictions, such as a chaperone on licensees who are accused of sexual misconduct or assault while an investigation is underway. This protects patients and consumers in the meantime because investigations and actions against the licensees are a lengthy process. 2, I would like to propose mandatory professional boundaries training, including sexual harassment and assault prevention training. This could be a licensee training requirement to be taken every few years. The reason to propose this here versus relying on employment laws is because many licensees are solo practitioners and not always they're not always subject to employment laws because they're too small of businesses, I should say. So the board, in my opinion, should be having their own regulation for their licensees. 3, the terms physical therapy and physiotherapy are not defined in the Chiropractic Initiative Act, nor the board's regulations. I would like a discussion of the BCE and the Physical Therapy Board coming together to clarify language in regards to what chiropractors can do versus what physical therapists can do versus what therapy an unlicensed person can perform. I believe when terms and policies are not defined is when ill intentions can occur. And then I do want to mention that I'm using the initials ML. I did submit written comments to you, which each of you should have. And for background knowledge, I was one of 3 female complainants and one of 4 women to testify against a former chiropractor whose license was revoked to December 2021. And this licensee had committed sexual misconduct against me. Thank you.
Thank you for your comments.
And there are no further requests for comment. Shall I close the public comment feature?
Yes, thank you so much.
Mm-hmm.
I would just note to the public commenters, we do receive your written comments and they have been read and they are distributed to the board members and committee members. So thank you for those.
Yes, I concur. With that, we are at agenda item 8, adjournment. Again, I want to thank Dr. Paris and Executive Officer Kristen Walker and new Assistant Executive Officer Tammy Pitto, and all of you at the BCE for all that you do for us. You make us look good and you help us get prepared, and we appreciate all the hard work you're doing. So keep it up, and I guess we'll see you in July.
Thanks, everybody. Have a good day.
Thank you.
Thank you. Meeting is adjourned at...
Congratulations, Tammy.
Yes, congratulations.
Thank you both.
And we adjourn at 1:53 p.m. Have a great afternoon.